In the heart of London, where the grand Gothic arches of the Royal Courts of Justice tower over the bustling Strand, a legal drama of unprecedented proportions has reached its dramatic climax. For weeks, the quiet, wood-paneled courtrooms have been transformed into a modern-day arena, hosting a clash of wills, wealth, and power that has captivated the public and sent shockwaves through the highest echelons of British society. This was not merely a dispute over documents or technicalities. It was billed as a historic reckoning. On one side stood some of the most recognizable figures of our age, individuals whose lives have been lived under the relentless, flashing glare of the public eye. On the other side was a media empire, a journalistic powerhouse accustomed to digging up secrets, but now forced to defend its own methods under the cold, clinical light of the judicial system. The atmosphere in London was thick with anticipation as the high-stakes trial progressed, with each day bringing fresh revelations, emotional testimonies, and a growing sense that the British establishment itself was on trial. It was a battle of narratives, a war fought not with weapons, but with centuries-old laws of privacy, public interest, and the freedom of the press. For the observers watching from the packed public galleries, the sheer scale of the conflict was breathtaking, a rare glimpse into the intense, often bitter friction between the royal family, global superstars, and the journalists who document their every move. The tension in the air was palpable as lawyers in traditional wigs and gowns carrying heavy bundles of files rushed through the stone corridors, preparing for a confrontation that would either redefine the limits of press freedom or deliver a devastating blow to some of the most famous people on the planet. This monumental legal battle represents the culmination of a decades-long struggle. To understand the gravity of what has transpired in that London courtroom, one must look back at the long and complicated history between the British monarchy, the entertainment elite, and the tabloid press. It is a relationship defined by a strange symbiotic tension, a mutual reliance that frequently descends into open hostility. For years, public figures have complained of intrusive tactics, of private lives laid bare in scandalous headlines, and of a feeling that no corner of their personal existence was safe from surveillance. The sense of grievance was not superficial. It was deeply personal, forged in moments of profound grief and public exposure. When the legal challenge was first launched, it was seen as a crusade led by a prince who had made it his life's mission to tame the press, joined by legendary musicians, iconic actors, and dedicated activists. They believed they had the momentum, the resources, and the moral high ground to deliver a definitive blow. On the streets of London, the trial was hailed as the ultimate media trial of the century, a moment that could redefine the boundaries of privacy in the modern digital age. Yet, as any seasoned legal expert will tell you, the courtroom is a sterile environment where emotion and rhetoric must ultimately bow to the absolute authority of verifiable proof. This was to be the ultimate test of whether historical grievances and deep-seated suspicions could be translated into the rigorous, undeniable evidence required by a court of law. Financial Times is show too. As we stand on the threshold of revealing the full extraordinary details of this legal storm and the dramatic ways in which this monumental case began to disintegrate, we invite you to join us on this journey. Before we dive into the complex web of evidence, hostile witnesses, and the staggering financial fallout that has left the legal world in absolute disbelief, please take a moment to subscribe to this channel and turn on your notifications. Your support allows us to continue bringing you these deep, highly detailed investigations into the cases that shape our world, ensuring you never miss a chapter of these unfolding stories. By subscribing, you become part of a community that values deep analysis and rigorous storytelling, keeping you informed as we navigate the complex, often treacherous waters of high-stakes legal battles. We are committed to bringing you the truth behind the headlines, dissecting the legal strategies, and explaining the real-world consequences of these historic confrontations. The stage was set for a confrontation that many believed would forever change the landscape of British media. The plaintiffs had assembled a formidable legal team led by some of the most expensive and high-profile barristers in the country, specialists in the delicate art of reputation management and privacy law. They entered the court with confidence, armed with a mountain of allegations spanning decades, accusing the newspaper group of employing a vast network of private investigators, using illegal wiretaps, and engaging in illicit activities to unearth their most sensitive secrets. The defense, however, remained resolute, refusing to back down, stubbornly denying every single claim as preposterous and insisting that their reporting was the result of legitimate, hard-nosed journalism. For weeks, the two sides locked horns in a grueling war of attrition, with the judge listening carefully to every argument, testing the strength of every assertion. To the casual observer, it seemed like a battle of giants, with the celebrity claimants appearing to hold all the cards, backed by their immense wealth and public sympathy. But beneath the glittering surface of fame and indignation, the foundations of the case were already beginning to show subtle, critical fractures. In the legal world, a case is only as strong as its weakest link, and when a high-profile litigation relies on a complex web of historical allegations and colorful characters, the risk of a catastrophic collapse is always hovering just beneath the surface. It is within this tense, highly charged atmosphere that our story truly begins, a tale of ambition, ego, and the harsh reality of the English legal system, where the grandest of crusades can suddenly find themselves running aground on the unforgiving shores of judicial scrutiny. The courtroom battle, which had begun with such soaring rhetoric and promise, soon transformed into a masterclass in legal self-destruction as the core of the claimant's case began to unravel in spectacular fashion. What was supposed to be a historic victory against the tabloid press rapidly devolved into what many legal experts are now calling one of the most comprehensive defeats in modern English legal history. Prince Harry, alongside 6 other high-profile co-claimants, including Baroness Doreen Lawrence and global music icon Sir Elton John, had launched a massive coordinated lawsuit against Associated Newspapers Limited, the powerful publisher of the Daily Mail and the Mail on Sunday. The allegations were grave, detailed, and highly dramatic, accusing the newspaper group of employing systemic, illicit methods to gather information, ranging from phone hacking and the placement of secret listening devices in homes and cars to the bribing of police officers and the illicit accessing of medical records. For years, these public figures had harbored a deep, burning conviction that their privacy had been systematically violated, and they believed this trial would finally expose the dark underbelly of tabloid journalism. However, as the trial progressed, the grand narrative of a widespread media conspiracy began to collapse under the weight of its own evidentiary deficiencies. The presiding high court judge ultimately dismissed all the claims across dozens of disputed articles, delivering a scathing judgment that tore through the claimant's case with clinical precision. In a devastating summary, the judge pointed out that instead of presenting hard, verifiable facts, the claimants had relied almost entirely on suspicion, broad inferences, and speculation to build their case. At the center of this spectacular courtroom collapse was the dramatic and highly unusual saga of the claimant's star witness, a colorful private investigator named Gavin Burrows. It was Burrows' initial, explosive statements that had formed the very foundation of the lawsuit, providing the seemingly concrete details of the alleged illegal surveillance operations carried out on behalf of the newspapers. The Daily Mail had initially dismissed his claims as lurid and preposterous, but the legal team representing the prince and his co-claimants had pressed ahead, confident that Burrows would deliver the decisive blow on the witness stand. What happened next, however, was a twist that even the most seasoned courtroom observers could scarcely believe. Before the trial could even get underway, Burrows suddenly and completely withdrew his support for the claimants. In a dramatic turn of events, he issued a subsidiary statement claiming that his original testimony was forged, unreliable, and should not be taken seriously. When the time came for him to testify, he did not appear as a champion for the claimants, but rather as a hostile witness testifying directly against them. The scenes of Burrows giving evidence via video link were nothing short of extraordinary, bordering on the absurd. Sitting in his solicitor's office wearing a pair of casual shorts, he openly laughed at the proceedings, mocking the claimant's prominent barrister, David Sherborne, and telling the court that the entire case was an absolute joke. He went even further, publicly describing the litigation as the biggest media scam in history. For any legal team, the sudden, public defection of their star witness is a catastrophic blow that would normally prompt an immediate reevaluation of the viability of the entire case. Yet, in a move that has bewildered legal commentators across the country, Prince Harry's legal team chose to press on, marching headlong into a judicial buzzsaw. This stubborn refusal to pull the plug on a clearly disintegrating case has raised serious, uncomfortable questions about the tactical decisions and professional judgment of the claimant's legal representatives. David Sherborne, a barrister famous for his love of the media spotlight and his theatrical appearances on the court steps in flowing robes, along with his team, chose to navigate the storm rather than seek an early settlement. While attempts were made behind the scenes to reach a compromise, including a flurry of secret discussions around Christmas Eve, the claimants apparently demanded financial terms and concessions that the publishers of the Daily Mail flatly refused to accept. The newspaper was determined to exonerate its journalists and defend its corporate reputation, refusing to apologize or pay compensation for allegations they maintained were entirely fabricated. The consequences of this high-stakes gamble are now coming back to haunt the claimants in the form of a massive, looming financial disaster. The publishers of the Mail, victorious and deeply vindicated by the absolute dismissal of the claims, are now going for the absolute jugular on the issue of court costs. In the English legal system, the general rule is that the losing party must pay the winner's legal bills, and in a multi-party litigation of this immense scale, those costs are astronomical. Early estimates suggest that the total legal bill for both sides could easily reach a staggering £50 million. While some of the claimants had taken out standard legal indemnity insurance policies, which theoretically cover around £2 million each, the spectacular failure of their evidence has thrown even this safety net into complete jeopardy. Insurance companies are famously diligent when it comes to avoiding massive payouts, and if they can show that the policyholders act unreasonably, relied on dishonest witnesses, or presented forged documents, the insurers may well void the policies entirely, leaving the individual claimants personally liable for the full crushing weight of the debt. The financial danger is further magnified by the complex legal concept of joint and several liability, which applies to the common parts of this joint lawsuit. While each of the 7 claimants is individually responsible for the specific costs associated with their personal allegations, they are collectively and individually liable for the shared legal expenses of prosecuting the overarching case. This means that Associated Newspapers is not obligated to politely collect an equal share of the common costs from each of the 7 participants. Instead, the newspaper group has the legal right to pursue a single, wealthy individual for the entirety of the joint debt. Given the deep animosity and the high-profile nature of this clash, there is widespread speculation in the legal community that the publishers will focus their formidable collection efforts directly on Prince Harry. The prince has already placed himself in an incredibly vulnerable financial position by reportedly agreeing to informally cover the legal costs of Baroness Lawrence, ensuring that she would not be left out of pocket by participating in the lawsuit. With his personal liabilities compounding rapidly, the final bill landing on the prince's desk could be truly ruinous, far eclipsing the settlements of past media disputes. The battlefield has now shifted from the dramatic arguments over privacy to a dry, protracted, yet incredibly brutal war over the exact figures, a process that legal experts predict could drag on in the courts for months, if not years, as both sides fight over every single penny. It is a stark, sobering reminder of what happens when a high-profile legal crusade is launched without the ironclad foundation of verifiable evidence, leaving its wealthy protagonists exposed to the unforgiving reality of the law. The fallout from this judicial disaster has extended far beyond the immediate financial wreckage, exposing a bizarre and highly questionable network of characters who were entrusted with assembling the evidence against the newspaper group. As the dust settles on the High Court ruling, the public has been treated to a fascinating and disturbing glimpse into the methods employed by the claimant's investigative team. It has emerged that the groundwork for the lawsuit was largely coordinated by Marcus Johnston, a former tabloid journalist who had previously been convicted of phone hacking. To many legal observers, employing a convicted phone hacker to lead an investigation into illegal news gathering is a choice that defies common sense, immediately handing the defense a massive tactical advantage. Johnston's methods were laid bare during the proceedings, revealing that his agency, Yellow Press, had paid various individuals substantial sums, reportedly up to £75,000, to secure statements and gather information. The defense argued with devastating effect that these payments were not made to legitimate journalistic sources, but were instead financial inducements to secure witness testimony for a civil trial. The judge's final ruling made it clear that the court viewed these arrangements with deep suspicion, suggesting that the evidence-gathering process had been compromised by a lack of objectivity and the involvement of individuals whose credibility was fundamentally flawed. Another key figure in this casting circle of witnesses was Jonathan Rees, a man who claimed he had been offered several £1,000s a month to provide a statement but had ultimately refused, telling journalists that he would not risk a prison sentence for perjury for the sake of a temporary payout. The revelation of these financial arrangements has cast a long, dark shadow over the entire prosecution, raising the alarming prospect of further civil actions, regulatory investigations, and even potential criminal scrutiny for those who orchestrated the campaign. The damage to the reputations of those involved has been compounded by the extraordinary and highly combative public reaction to the court's decision. Following the dismissal of the claims, Prince Harry and Baroness Lawrence issued a highly critical joint statement that took the unprecedented step of attacking the integrity of the judiciary itself. The statement described the High Court judgment as a complete and obvious whitewash, suggesting that the judge had gone to extraordinary lengths to protect and exonerate the newspaper group. In the deeply traditional world of the English legal system, such an open, aggressive challenge to a judge's neutrality is viewed as an act of extreme foolishness, particularly when the very same judge is scheduled to preside over the upcoming critical hearings on how the massive court costs will be distributed. Experienced litigators have pointed out that while a disappointed party is always free to appeal a decision through the proper legal channels, launching a public, personal attack on a judge is a tactical error of the highest order. The professional standards bodies, including the Solicitors Regulation Authority and the Bar Standards Board, are already facing calls to investigate the conduct of the legal teams involved, particularly after the judge highlighted a serious error of professional judgment by a senior solicitor who had signed off on a critical witness statement prepared by an unqualified researcher. For the lawyers who stood on the courthouse steps basking in the media spotlight, the dream of a historic, career-defining victory has rapidly dissolved into a nightmare of potential regulatory sanctions, damaged professional reputations, and a line of incredibly angry, financially ruined clients looking for someone to blame. This historic courtroom defeat also represents a devastating, perhaps terminal blow to the wider organized campaign against the British popular press. For years, groups like Hacked Off have used the grievances of high-profile celebrities to lobby for state-backed press regulation and to demand a second phase of the Leveson inquiry into media ethics. They envision this trial as the perfect vehicle to force the government's hand and finally impose rigid, statutory controls on tabloid journalism. The High Court judge, however, was highly alert to this political agenda, explicitly stating during the trial that his courtroom would not be used to conduct a public inquiry by proxy. With this comprehensive defeat, the campaign for tougher press regulation has lost its most powerful weapon, leaving the anti-press lobby facing its most significant setback in over 15 years. The hope of establishing a legal precedent that would make it easier to sue newspapers for historical privacy violations has been thoroughly crushed, giving a massive boost of confidence to publishers who have argued that state regulation would stifle investigative journalism and destroy the freedom of the press. While some legal experts believe that we will eventually see more privacy disputes in the future as the digital age creates new complex forms of online harassment and data theft, the era of the multi-claimant celebrity-driven blockbuster privacy lawsuit against traditional print media is likely over. The lesson of this trial is clear, brutal, and unforgettable. No matter how famous you are, no matter how deep your pockets, and no matter how intensely you believe you have been wronged, a court of law demands absolute, verifiable, and untainted evidence, and without it, even the most glamorous of crusades will end in ruin. As the legal world looks ahead to the crucial cost hearing scheduled for the end of July, the true scale of the financial impact will finally begin to take shape. While the detailed assessment of the exact bills could drag on for years, the judge has the power to order an immediate massive payment on account. With legal circles speculating that Prince Harry and his co-claimants could be ordered to pay up to £10 million within 14 days of the ruling, subject to a punitive 8% interest rate if they fail to meet the deadline. For the prince, whose public departure from royal duties was driven by a desire for independence and privacy, this defeat represents a deeply personal and financially devastating setback, locking him into a protracted, exhausting legal battle over the very institutions he sought to defeat. The grand campaign that began with a wave of indignation and a promise of historic justice has concluded not with a triumphant press conference on the steps of the High Court, but with the quiet clinical scratching of a judge's pen, leaving behind a trail of staggering debts, shattered strategies, and a stark reminder that in the cold halls of justice, facts will always triumph over fame. Thank you for joining us for this comprehensive, three-part investigation into one of the most remarkable legal chapters of our time. Your engagement is what allows us to produce these highly detailed analyses of the cases that define our